If you're like most people, you know you should have a will, but you've never gotten around to it. And I mean that bit about most people. Fewer than 1/3 of adults in America have a will, and it's not just the young adults. 1/2 of the 55 and over crowd still doesn't have a will or any other estate planning. So the good news is you can stop feeling like everyone's got it together and you don't. The bad news is a lot of people don't have it together. So let's fix that, and let's do it today. In about 2 minutes, I'm going to show you in detail how to get a completely free, completely valid will for California residents. It's called the California Statutory Will form. I'll also show you how to get a completely free, completely valid, durable power of attorney in Advanced Healthcare Directive. Now, if you just want a link to the actual forms, you can find them in the video description and the first comment down below. If you want a detailed walkthrough on how to fill out your will form, keep watching. After that, I'll have some discussion of what your will does and what it doesn't do, and how it might not be exactly what you think it is. I need to cover 2 short points before we get started. First, it's important to realize that if you don't live in California, these forms probably won't work for you. You're free to stick around, but don't print and sign these and think that your estate planning is taken care of. It won't be. There are a handful of other states with statutory will forms. I think it's Maine, Michigan, New Mexico, and Wisconsin. But I don't practice law in any of those states, so I can't tell you anything about them. For those of you from California, you can proceed with confidence. As an attorney in California, I've practiced for years creating and administering wills and trusts. I sat down with hundreds of clients to help put together plans to take care of their families after they were gone. Now I'm employed as an attorney for a California state government agency, so I'm not trying to get any more estate planning clients. That means I have the freedom to give away everything. And that's what I'm doing here. I can promise you that this video will not end by asking you to buy anything. A free will is free here. Now, I will take some time at the end to explain the limitations of the free documents and when it might make sense to sit down with an attorney and have a consultation, but I am not that attorney. I just want to get this information into as many hands as possible so that the 20 million adults in California with no estate planning at all can at least get some basic protection in place. Here's the second thing. I have to give a very lawyer-like disclaimer, and I'm sorry you have to listen to it, but it's important, so please do. A lawyer's job is to give legal advice to a client about the client's specific situation. A lawyer studies the law so that he can help a client know how the law applies to that client specifically. Sadly, I don't know you, and I don't know your situation. That means this video is not and cannot be legal advice. I'll talk about general scenarios here, but I have no way of knowing how nearly they match your situation. I hope you take this video and you learn from it, but realize that there might be some reason you don't fit the general scenario. If you have any questions, please consult an attorney who can sit down with you and get to know your specifics and give you specific advice that will help with your specific situation. There. That's out of the way. Let's get on to the free will. So California's had a statutory will form, it's right here, since the 1980s. It's changed several times since then, but the general idea has stayed the same. The state legislature wanted to give people an easy alternative to not having any estate plan at all. They basically promised to everyone in California, hey, if you print this out and you fill it correctly and you sign it the right way and you have it witnessed according to the instructions, this will work in California as your will after you die. You can see the entire text of the statutory will form in section 6240 of the California Probate Code, or you can just download it from one of the links below. There's a detailed walkthrough coming up, and you'll want to have the will form and a pen in hand so you can fill it out today, right now. And while you're downloading the statutory will form, please also download the forms for a uniform statutory power of attorney and an Advanced Healthcare Directive. Your will kicks in when you die, but statistics say that most people actually become disabled at some point before they die. It might be illness, or it might be injury, or it might just be age, but there will likely come a point when you need someone else to make important decisions on your behalf. Or even just to sign some papers that require your signature, but you can't, either because you're physically or you're mentally unable to sign them, do it yourself. That's what the power of attorney and the Advanced Healthcare Directive are for. I'll have some separate videos for those, because otherwise this will get really long, but you should definitely print them out and get those taken care of, get them ready as well. I'll see you back here after you have the will and the other forms printed out. Go ahead and pause the video to download the forms and print them. Okay, I'm continuing here with the assumption that you've printed the California Statutory Will form and we're ready to talk about it. To make this super easy, I'll put the form up on my screen and we'll look at it together.
Okay, this is the actual PDF file that I've downloaded, and hopefully you have downloaded as well. Have it in front of you with a pen, and we can fill it out right now. The first 2 pages are questions and answers and some really brief instructions. I'm not going to go through these now. I hope that you do. There's interesting information in there and things that you should know. Page 2, when we get to page 2, you see there's some instructions here at the very bottom. These are very simple, but they have to be followed very carefully. First, read the will. Read the whole thing first. It's arranged kind of in a backwards way, and we'll get into that as we look at the will pages themselves. Fill in the blanks. Only fill in the blanks. Don't write anything else on the will. Don't cross anything out. And don't fill in all the blanks, because there's some that you probably won't want to fill in. And number 3, date and sign the will. There are instructions for how you do that and how your witnesses thereafter sign it at the end here. So we'll go out to the first page of the actual will itself. And I'm going to make this just a little bit bigger so we can see it better. There it is. So the first page, very first thing everyone needs to do is print your full name. You do this in the box right up at the top here. You just print your name, whatever your full name is. The first clause says, this is my will. I revoke all prior wills and codicils. So if you have any wills that you made in the past, those all are revoked when you create a new will. You can't have more than one will that's enforceable at any given time. The first section of the will we're going to get to is what you give away to who. And that's in paragraphs 2, 3, 4, and 5, but we're actually going to skip right down to 5, and I'll explain why in just a minute. So skipping down to paragraph 5, it says, the balance of my assets. So if we look at this, except for the specific gifts made in paragraphs 2, 3, and 4 above, I give the balance of my assets as follows. So here in paragraph 5, you can say, I want to give everything I have to certain people. And these choices are already predefined for you. Choice 1 is, I want to leave everything to my spouse or my domestic partner, and this has to be a domestic partner who's registered with the California Secretary of State, not just somebody you're living with. Or if not, because they don't live as long as I do, then to my descendants. And my descendants means my children, and if any of those children are predeceased, that portion would fall down to their children, if there are any. So you can say, in choice 1, everything to my spouse or domestic partner, and if not, because they don't live as long as I live, then to my children. Choice 2 is, nothing to my spouse or domestic partner. Go ahead and just give it all to my descendants, my children and possibly their children. Choice 3 is, everything to a specific person, and you write that person's name down here on the line below choice 3. And choice 4 is, everything equally among the following people. So you can write any number of names on those lines there, and your property, your estate will be split equally among them. The way you actually make the choice is by signing in one of these boxes. So you can only sign in one box. If you sign in more than one box, if you don't sign in any box, then the court doesn't know what you meant to do, and your assets are given away according to law, not according to this will. So choose either choice 1 and sign this box, choice 2, sign this box, 3 in this box, or 4 in the choice 4 box. That's how you say, I'm going to give away everything to these people. Now, if you want to make specific gifts, if you want to say, give your home to somebody other than those people that you named here in paragraph 5, you can do that. If you want to give your tangible stuff, all the things you own, to somebody, you can do that in paragraph 3. If you want to give specific cash gifts, say $10,000 to this organization, or $1,000 to each of my grandkids that I'm going to name here, you can do that in paragraph 4. So paragraph 5 says the balance. And if you haven't taken any parts of your estate out in paragraphs 2, 3, and 4, the balance is just everything. For a lot of people, what they do is leave 2, 3, and 4 blank and just make a choice in the paragraph 5 balance of my assets portion. But if you do want to make a specific gift of your residence or something like that, we'll go up and see how that would work. Paragraph 2 here says, a specific gift of my personal residence. So if you don't want this going to the same people who you have in paragraph 5, then you either choose choice 1, 2, 3, or 4. These are the same choices as before. And you sign your name in the box. And if you need to write somebody's name down here in choice 3 or 4, you do that. That's how you give your home away to somebody who's not the same people you chose in paragraph 5. If you look in paragraph 3, you can give away your stuff. So this is automobiles, your household, your personal effects, the things that you own. All of those things, you can say, you know what, I'm leaving everything else to my kids, but I want all the things I own to stay with my spouse or domestic partner. And you would choose choice 1 for that. Or you could say, I'm giving everything else to this organization that I really believe in, but I want to give my personal things to my family. And that would be maybe your children. So that could be choice 2. You could also choose choice 3 or choice 4. These are the same choices again through all of these paragraphs 2, 3, 4, and 5. But this is to give away the stuff that you own. And then finally in paragraph 4, you can give away specific gifts of cash if you want. So you can say, this person or this charity will get $1,000 or $10,000 or whatever. You write the amount of the gift in, you write the person or the organization's name, you sign your name. This box right here makes the gift. So you have to put all 3 of these things in. Who it goes to, how much it is, and then you sign it to actually make the gift. And you can do that for up to 5 boxes here. That's as many as fit in the California Statutory Will form. So a lot of people, like I said, will just use paragraph 5. They'll say everything goes to either my spouse or my kids or some other people, and use the appropriate choice for that. Some people will leave the home to someone different or the tangible stuff to someone different, or make cash gifts beyond the balance of the assets, and that's 2, 3, and 4 if you want to use them. We'll come down now to paragraph 6. This is actually probably the most important paragraph for people who have minor children, because your stuff will eventually get to your kids if you have minor children, but who you have take care of them is a choice that you want to have some say in. This is when you nominate a guardian of any children you have under age 18. Anybody who's a child of yours and under 18, when you die and the child doesn't have a living parent, you can choose a first choice for someone to raise the child, a second choice, and a third choice. And people are given the option to be that guardian in that order. It may be that your first choice dies before you, or it may be that person is just a terrible time for them to take on the raising of some new children. Whatever it is, you have 3 choices there, so that if your first choice can't do it, then somebody else can. Write the name of your first choice for guardian, your second choice for guardian, and then your third choice for guardian for any minor children you have. And if you don't have any minor children, you don't have to fill any of this in. You can leave 6 completely blank. Now you can use paragraph 7 to make some decisions about your young children as well. I've already named in paragraph 6 the guardians of the person, that is the people who will raise any minor children you have. This allows you to name either the same person or someone else as the custodian of assets, or the guardian of the property, the guardian of the inheritance that you're leaving for these young children. And you can say here that as soon as they turn 18, they get their inheritance. That's the default. If you want to choose some other age, then you can actually say up to age 25, you know what, when I was an 18-year-old, I would have squandered my inheritance. I don't want my 18-year-old child to do the same. Let's wait until they're a little more mature. Write that age down in this box here. So whatever age it is that you want your kids to get their inheritance outright. And you write here in these boxes your choices for the custodian of assets, or the person who will take care of the assets and hold on to them until they're given to your children as they reach the age that you specify. This can be the same person that you choose for paragraph 6, the guardian of the person, or it can be a different person. When you get to paragraph 8 here, this is the choice that most people think of when they're thinking about a will, is who will be my executor? Who will be the person who manages the estate and goes to court and hires a lawyer if needed and a real estate agent if needed and sells the property and eventually gives it out to the people who I name as beneficiaries. Your executor can be one of your beneficiaries, but doesn't need to be. Your executor is compensated for the work they do, so they don't have to be a beneficiary. They can actually draw compensation from the estate under California probate law. So you'll name your first choice, second choice, and third choice for the person who manages the entire estate and eventually gives it to the beneficiaries after it's been through the probate process. And paragraph 9 is the bond requirement. So a court will frequently require a bond, that is insurance, basically, that your executor has to buy, saying, if I behave badly and make off with some of the assets of the estate, then this bond, this insurance policy, is in place to pay the beneficiaries. If you trust the person you're choosing as your executor, you can actually say, that bond isn't going to be required. I don't want my estate to be used up paying a bond. I want it instead to just go directly to my beneficiaries. And so you can sign in this box saying no bond shall be required. And that allows your executor to serve without a bond. The court still requires accountings and overlooks things, but that insurance policy isn't in place. This last page of the will is one that has to be done just right, or the rest of the selections you made don't matter. This is where you sign and where your witnesses sign the will. Let's just go through it sentence by sentence. Notice at the top, you must sign this will in the presence of 2 adult witnesses. You have to have them there in the room with you as you sign it. So the witnesses must sign their names in your presence. And before you sign, you must read the following sentence. This sounds a little bit silly. Just do it. Just read the sentence. The sentence is, "This is my will. I ask the persons who sign below to be my witnesses." So you get in the room with 2 people who are adults who are not receiving any assets under the will. And you say, "Will you be my witnesses?" And they say, "Sure." And you sit down with them and you say, "Okay, this is my will. I ask the persons who sign below to be my witnesses." And you take your pen and you put the date and you put the city where you're signing, and then you write your signature in the box that says signature of maker of will. So you've signed your will. Now the 2 adults who are signing must read the following clause before signing. We'll read it now. Each of us declares under penalty of perjury under the laws of the state of California that the following is true and correct. A. On the date written below, the maker of this will declared to us that this instrument was the maker's will and requested us to act as witnesses to it. So that's why you had to read that sentence at the top, to make sure that that was communicated to your witnesses. B. We understand this is the maker's will. C. The maker signed this will in our presence, all of us being present at the same time. D. We now, at the maker's request, and in the maker's presence, sign below as witnesses. E. We believe the maker is of sound mind and memory. F. We believe that this will was not procured by duress, menace, fraud, or undue influence. G. The maker is age 18 or older. And H. Each of us is now age 18 or older, is a competent witness, and resides at the address set forth after his or her name. Then one of those witnesses will date it. Here's the date, here's the year. Each of them will sign it in the box, then print their name and print their address under it. That's all there is, but this has to be done right. If you don't say the words up here, if you don't say, "This is my will, ask the persons who sign below to be my witnesses," then they can't declare under penalty of perjury that you told them that. If you don't date it and put the city and sign it, and they don't fill this out as it's set out here, then your will can be called into question later. You don't want that. Just follow the procedure. Do it very carefully. Okay, quick recap. Let's go to the very top. All right, you print your full name at the very top. You may choose to use either choice 1, 2, 3, or 4 for your specific gifts in paragraphs 2, 3, and 4. That is to give away your home, your tangible personal property, and any cash gifts. Or you may choose just to leave some or all of those blank and go to 5. You make a choice by signing your name in the box next to that choice. This top one is choice 1, the second one is choice 2, etc. If you're choosing 3 or 4, you need to write the names that apply to 3 and 4. You get down to number 6, paragraph 6, you choose the guardian who raises your minor children. Paragraph 7 could be the same or different people. You choose the custodian of assets. You choose at what age your children can receive their inheritance. You choose your executor, the one who manages the whole estate. You choose if bond will be required or if not for your executor. And then you sign according to the instructions on the signing page. That's all there is to it. It's a pretty simple will. It doesn't do everything, but if you do this, it will do exactly what you ask it to do.
And that's that. If you've printed and filled out the will, you just need to sign it in front of 2 witnesses who are at least 18 years old, are not receiving anything from the will. Those 2 people will watch you sign, they'll sign themselves as witnesses, and you'll have a valid California will. Congratulations! You are in better shape than most people in California. But let's talk for a minute about what that means. I know it's tempting to sign off right now, but I hope you don't. When I would sit down with clients to do this, I'd spend at least an hour with them because there's some important things they needed to know. And it's important for you to know too. It's important to understand exactly what you have and what you don't have in your will. First, let's take some time to debunk or clarify common misconceptions about your will. And then I'll briefly answer a question that's especially relevant to California. Should you have a will or should you have a living trust? First, some misconceptions. In my estate planning practice, people came in with a lot of interesting ideas about wills and trusts, and that's understandable. Most people have no relevant experience. They've never been in charge of administering an estate. More than 2/3 of them haven't even made their own will. So in case you've picked up one or more of these, let's straighten them out here. First, if I don't have a will when I die, the government will take everything. Related, but more specific, my will lets me avoid estate taxes. Third, my will keeps my estate out of probate court. Fourth, my will keeps my kids from fighting over my estate. Fifth, my will transfers all my assets to the designated beneficiary. 7, my will has to be typed and notarized. 8, I should keep my will in my safety deposit box at the bank. And 9, I don't need a living trust because I have a will. So let's address those one by one. Some will be super fast and a few will take some more time. First, if I don't have a will when I die, the government takes everything. I hear that a lot, and it's very rarely true. If you don't have a will, you don't get to choose who receives the property of your estate, but it's usually not the government. Now, California law includes a whole family tree of people who are entitled to receive your estate before the state itself steps in and takes over. Anyone even remotely related to you has a better claim than the state does. However, if you don't choose your beneficiaries in a will or trust, and there really is no one even remotely related to you who steps up to claim your estate as their inheritance, it has to go somewhere and the state steps in and takes it. Second, my will lets me avoid estate taxes. Now, this simply isn't true. Your will has no effect on the taxes you'll owe when you die. But in 2020, this doesn't actually matter to many people because almost no one actually owes estate taxes. The federal estate tax exemption lets you give over $11 million before any estate tax kicks in at all. What does that mean? That means that fewer than 1 in 1,000 people who die will owe any estate tax. And while some states do have an inheritance tax, there isn't one in California. So most estates don't owe any tax except the normal income tax that the estate pays if it earns income before the assets are distributed. That income tax is due whether you have a will or not. There's no escaping the tax man. The takeaway is most people never have to worry about estate taxes. If your estate is large and complex enough to require tax planning, don't watch this. Go talk to an attorney who can walk you through how the law interacts with your specific situation. The third misconception is, my will keeps my estate out of probate court. And this is absolutely not true. In fact, what your will does is get your estate into probate court on your own terms. If you have no will at all, your estate goes to probate and the law chooses who gets to administer the estate and who receives the assets of the estate. If you have a will, your estate goes to probate court and your will says who acts as your executor and who your beneficiaries are. But you still go to probate court and a judge still oversees the administration. If you want to avoid probate court entirely, there are lots of ways to arrange that, using a trust or using transfer on death tools or some of each, but that's a conversation you should have with an estate planning attorney who can give you specific advice about the best ways to transfer your specific property. Yeah, another misconception, my will keeps my kids from fighting over my estate. I'm sorry to say that isn't true either. There's nothing you can do to keep your kids from fighting while you're alive. This doesn't change when you've died. You can, however, do a few things which decrease the chances of certain types of fights. Just making a will is a start. Some people also write a letter to their children to explain their decisions and affirm their love and affection and ask that the kids try to get along during this difficult time. Another thing would be to include a no contest clause in your will. A no contest clause is a provision that automatically disinherits somebody who brings a certain type of lawsuit against your chosen executor. Now, the California Statutory Will form doesn't include this clause. If you're concerned about a huge family feud coming out of your estate, it would be wise to talk to an attorney about the best way to mitigate that in your estate planning. In the end, though, we can put incentives in place to behave well, but we can't ever force our kids, whether we're alive or whether we're dead, to behave the way we wish they would. The fifth common misconception is that my will transfers all my assets to the designated beneficiaries. Now, this is a really interesting one because it seems reasonable, and it could be true, but it usually isn't. There are many kinds of property that include a named death beneficiary on the title of the property. Life insurance is a common example. You might own a policy, and you pay the annual premiums while you're alive, but there's a named beneficiary on the policy who actually gets the cash after you die. But life insurance isn't the only example. Your pension or your retirement account probably has a named death beneficiary as well. Your bank accounts or your investment accounts might have one. If you hold title to real estate or other property in joint tenancy, the surviving owner automatically becomes the sole owner when you die. There are other ways that this happens as well. Your will catches any property that doesn't have its own named death beneficiary on title and passes that property along to the beneficiaries of your will. But property that includes a named death beneficiary as part of its title actually transfers outside of your estate. So it's really important to go back every once in a while and make sure that anything you own with a named death beneficiary has the names you intend. I've had clients who found that an ex-spouse or a deceased sibling is the named beneficiary, or that there simply is no beneficiary named at all. This happens frequently when companies have gone from paper records to computer records and something gets lost. If you're making a will today, take some time to check and make sure that your named beneficiaries are correct. You can usually do it online or with a short phone call. Number 6, my will has to be typed and notarized. Now, it's true that in some places a will can be notarized, but not in California. Your will should be signed by you in the presence of 2 witnesses, and then signed by them with the proper witness attestations as used in the California Statutory Form Will. And as for typing, it's not a requirement at all. You can simply write out your entire will longhand, but the California Statutory Will includes pre-printed language which makes it easier to use. So you can just write in your selections on the form and it'll be valid. Number 7, I should keep my will in my safety deposit box at the bank. A lot of people do this. You should keep your will somewhere safe. The potential problem with keeping it in your safety deposit box is that some banks make it really difficult for anyone except the court-appointed executor to get into a safety deposit box. And your executor will need to file your will with the court to become the executor. So there are ways around this, but no one wants to spend time fighting with the bank just after a spouse or a parent or some other loved person has died. It's a difficult time already. So we keep our estate planning documents safely in our home office, and there are scanned copies available for relevant people. You should choose a secure place that works for you and your family wherever that is, but keep in mind that a safety deposit box has some drawbacks. And finally, I don't need a living trust because I have a will. Now, this one takes a little more discussion. A will and a living trust seem to do the same basic things, but they do them in entirely different ways, and one might be better than the other for you. A living trust can do more than just a will can. A will kicks in when you die. A living trust can plan for a time when you're incapacitated or when you need some help taking care of things, but you're still breathing. A trust can be closely tailored for your specific needs, while a will mostly just answers the basic questions. It's how you tell the probate court who you want to act as your executor, who you want to take care of your minor children if you have any when you die, and who you want to be your beneficiaries. But many people want to avoid probate court altogether, and usually it's for 3 reasons. First, probate court is a very public process. Anyone who wants to can see your will, find out who received what, and listen in on the discussions between the lawyers and the judge. Second, probate can take a long time. In California, it's almost impossible to get through probate court in less than 7 months, and that's if everything goes perfectly. Usually it takes longer before anything can be distributed from the estate. Third, and most importantly for most people, probate court, especially in California, can be really expensive. There are court filing fees and probate appraisal fees and newspaper publication fees and other costs that usually come out to between $1,500 or $2,000 for the estate. And then there are the bigger costs. Those are attorney and executor fees. Those are calculated as a percentage of the estate. For an example, an estate worth $300,000, which in California might be a modest home and a small bank account, the attorney fees could be $9,000 on that. And the executor also has the option to take $9,000 in compensation for administering the estate. With the other $2,000 in cost, that's as much as $20,000 in fees on a $300,000 estate. Many other states use different ways to calculate attorney and executor compensation, but California statutory commission law can make probate court pretty expensive pretty quickly. Because of that, for a lot of people it might make sense at some point to pay for a living trust, which can avoid probate court entirely, so that their family is left with a larger percentage of the estate. A trust is not something I'd recommend as a DIY project, though. It would require sitting down with an attorney, and depending on where you're at in the state, it might cost between $1,500 and $3,000, even more than that in some places. That's not a lot compared to eventual probate fees, but it can be a lot of cash to come up with for estate planning right now. A living trust is also more complex than a very simple will, and it might require more updates and maintenance, which usually carries some additional cost too. On the other hand, the California Statutory Will form is free. It's right here. You can print it out and use it and fill it out today. And even if you do plan on getting a living trust someday, finishing a will now might be a responsible and prudent choice. And that's as much as we're going to cover now. I'll add links below to much briefer walkthroughs of the durable power of attorney and the Advanced Healthcare Directive. Thank you for participating. I hope it's been helpful. I hope you've got some planning done. Take care now.